I never thought a drainage ditch would become the center of my life's biggest legal battle. But when the Sunset Hills HOA decided to turn my property's natural floodwater management into their personal bike path, they set in motion a disaster that would cost them everything. My name is Marcus Oakes, and I had lived in my house on Willowbrook Lane in Beaverton, Oregon, for exactly 8 months when the trouble started. The property was perfect, a 3-bedroom ranch-style home with a large backyard that sloped down into a natural drainage ditch running along the rear property line. The ditch was about 15 feet wide and 4 feet deep, lined with river rock and native grasses. It had been there for decades, part of the original drainage system installed when the neighborhood was built in the 1970s. During Oregon's wet winters, that ditch channeled runoff from the hills behind my property and 4 neighboring lots, directing water safely toward the municipal storm drain system 2 blocks away. The real estate agent had specifically mentioned the ditch during my walkthrough, explaining how it protected my basement from flooding. I had even consulted with a civil engineer friend before buying, and he confirmed that the drainage system was well designed and essential for the neighborhood's water management. Everything was documented in my property survey, showing the ditch clearly within my property boundaries, about 10 feet from the back fence line. Things were peaceful until March, when I received my first violation notice from the HOA. I was in my garage, working on restoring a 1967 Mustang, when I found the bright orange envelope stuffed in my mailbox. Inside was a letter on official Sunset Hills HOA letterhead, signed by Patricia Pemberton, the HOA president. "Dear Mr. Oakes," it read, "it has come to our attention that the overgrown drainage area at the rear of your property at 847 Willowbrook Lane presents an unsightly appearance that detracts from our community's aesthetic standards. Per HOA Bylaws Section 4.7, all homeowners must maintain their yards in a neat and attractive condition. You have 14 days to landscape this area appropriately or face fines of $100 per day." I read the letter 3 times, feeling my blood pressure rising. The overgrown drainage area was a functional drainage ditch, doing exactly what it was designed to do. The native grasses prevented erosion, and the whole system worked perfectly. I had done absolutely nothing wrong. The next morning, I called the number listed on the HOA letterhead. A woman answered on the 3rd ring with a sharp, "Sunset Hills HOA, Patricia speaking. Hi, this is Marcus Oakes from 847 Willowbrook. I received a violation notice about my drainage ditch, and I think there has been a misunderstanding. That ditch is part of the property's drainage system. It is actually on my property survey and serves an important function." "Mr. Oakes," Patricia said, her tone dripping with condescension, "I am well aware of what is on your property. The fact remains that it looks terrible. Several neighbors have complained. We are trying to maintain property values here." "Which neighbors?" I asked. "That information is confidential, but I can tell you that the board has been discussing this issue, and we believe that area would be much better suited as a community amenity. Have you considered allowing us to convert it into a walking path? It would really beautify the neighborhood." I felt a chill run down my spine. A walking path, that is a drainage ditch. It carries thousands of gallons of water during heavy rains. You cannot just pave over drainage infrastructure. "Well, we will see about that," Patricia said. "You have your notice. Either bring the area into compliance or we will have to take further action." She hung up before I could respond. I immediately contacted my real estate attorney, Daniel Morrison, who had handled my home purchase. After reviewing my property documents, He sent a certified letter to the HOA explaining that the drainage ditch was a legal, documented part of my property's infrastructure, that it was properly maintained, and that any attempt to force me to alter it would be met with legal action. For about 3 weeks, everything went quiet. I thought maybe common sense had prevailed. I was wrong. On a Tuesday morning in early April, I woke up to the sound of heavy machinery. I threw on jeans and a t-shirt and ran outside to find 2 dump trucks, an excavator, and a paving crew setting up at the back of my property. A chain-link fence had been erected overnight, cutting across my backyard and enclosing the drainage ditch. I sprinted across my lawn, still barefoot. A man in a hard hat and reflective vest was directing the excavator toward the ditch. "Hey, stop! What the hell are you doing?" I shouted. The man turned around, annoyed. "HOA project. We have got work orders to fill in this ditch and install a bike path." "You need to step back behind the fence, sir. This is my property. You cannot just come onto my land and start construction." "We have authorization from the HOA," he said, pulling out a work order. "Says right here, Community Improvement Project approved by the board." "I do not care what your paper says. This is private property and you are trespassing. I am calling the police right now." I ran back inside and dialed 911. Within 10 minutes, 2 Beaverton police officers arrived. I showed them my property survey, proving that the entire area where the construction crew was working fell within my property boundaries. The officers examined the work order the contractors had, which mentioned nothing about property ownership or easements. "You are going to need to cease work immediately," Officer Rodriguez told the foreman. "This is a civil property dispute. You cannot do construction on private property without the owner's permission, regardless of what the HOA told you." The foreman was furious. "We have got a $50,000 contract here. Who is paying us for the mobilization costs?" "That is between you and whoever hired you," Officer Rodriguez said. "But if you do not clear out, you will be charged with trespassing." The crew packed up and I thought that was the end of it. I was naive. That afternoon, I received an email from Patricia Pemberton with the subject line, "Emergency HOA Assessment." She informed me that due to my interference with approved community improvements, the board was levying a special assessment of $15,000 against my property to cover the costs of the aborted construction project. I forwarded the email to Daniel, my attorney, and he immediately filed for a temporary restraining order against the HOA. We had a hearing scheduled for the following week. In the meantime, I started receiving daily violation notices for increasingly absurd infractions. My grass was allegedly 0.3 inches too tall. My mailbox was not regulation black. My garage door was left open for more than the permitted 15 minutes. Each violation came with a $100 fine. I documented everything, took photos, measured my grass height with a ruler, and kept every piece of correspondence. The hearing for the restraining order took place in Washington County Circuit Court on a rainy Thursday morning. Daniel and I sat at one table while Patricia Pemberton and the HOA's attorney, a slick-looking guy named Richard Vance, sat at the other. Judge Helen Kowalski presided. She was in her early 60s, with sharp eyes that suggested she did not suffer fools. "Let me make sure I understand this correctly," Judge Kowalski said, looking over the filings. "The HOA attempted to conduct construction on Mr. Oakes's private property without his permission, claiming authority they do not actually possess, Your Honor." Richard Vance stood up. "The HOA has broad authority under the CC and Articus to maintain and improve common areas. This drainage area, while technically on Mr. Oakes's property, serves the entire community and therefore falls under the HOA's purview." Has the HOA established an easement for this purpose? The judge asked. Not formally, but the precedent. That is a no, then, Judge Kowalski interrupted. Mr. Morrison, your client's position, Daniel stood. Your Honor, my client owns the property in question free and clear. It is shown on his deed and survey. The drainage ditch is part of his property's essential infrastructure. The HOA has no legal right to modify it, and their attempt to do so, coupled with retaliatory fining, constitutes harassment. Judge Kowalski looked at Patricia, who was whispering urgently to her attorney. Miss Pemberton, can you explain why the HOA board believed it had the authority to pave over a drainage system? Patricia stood up, her face flushed. Your Honor, that ditch is an eyesore. It is bringing down property values for everyone. We had a landscape architect design a beautiful bike path that would serve the whole community. Mr. Oakes is being selfish and unreasonable. That is not what I asked, Judge Kowalski said coldly. I asked about legal authority. The bylaws give us the authority to maintain community aesthetics, Patricia insisted. Not on private property without permission, the judge said. She flipped through more documents. I am granting the temporary restraining order. The HOA is prohibited from entering Mr. Oakes's property, from continuing construction plans related to his drainage ditch, and from levying fines related to this dispute. We will have a full hearing in 60 days to address the broader issues. This court is adjourned. I felt a wave of relief wash over me as we left the courthouse. Daniel clapped me on the shoulder. That went well, but be prepared, HOAs do not usually give up this easily. He was right. For the next week, things were quiet, too quiet. Then, on a Wednesday evening, I came home from my job at an aerospace engineering firm to find a notice taped to my front door. It was from the City of Beaverton Engineering Department, stating that they had received a complaint about unauthorized modification to municipal drainage infrastructure, and would be conducting an inspection the following week. I called the number on the notice and got transferred to a city engineer named Tom Peterson. Mr. Oakes, we received a complaint that you have been interfering with the neighborhood drainage system, Tom said. That is completely false. I have not touched the drainage ditch. In fact, I have been trying to protect it from the HOA who wants to pave over it. There was a pause. The HOA wants to pave over a drainage ditch. Yes, they want to turn it into a bike path. That is insane. Do you have any documentation about this? I sent Tom everything: my property survey, photos of the ditch, the court filings, and all correspondence with the HOA. 2 days later, he called me back. Mr. Oakes, I have reviewed everything you sent. That drainage ditch is a critical part of the neighborhood's stormwater management system. According to our records, it was installed in 1974 as part of the original subdivision approval. If someone paves over that ditch, you are going to have serious flooding problems. I am going to send a letter to your HOA explaining this. Thank you, I said, feeling genuinely grateful that someone with actual engineering knowledge was involved. Tom sent his letter, which clearly stated that the drainage ditch was essential infrastructure and that any modification would require city approval, engineering studies, and an alternative drainage plan. He estimated that designing and building an alternative system would cost upwards of $300,000. I thought this would finally end the madness. Instead, it seemed to make Patricia even more determined. At the next HOA board meeting, which I attended along with about 30 other homeowners, Patricia announced a community improvement initiative that had been in the works for months. She unveiled architectural renderings of a beautiful bike path running through the neighborhood, connecting to the local trail system. The centerpiece was a paved path running exactly where my drainage ditch was located. This will increase all of our property values, Patricia gushed. We have already received approval from most of the affected homeowners. Except you do not have approval from me, and it is on my property, I said loudly from the back of the room. Patricia's face went red. Mr. Oakes, you are being incredibly selfish. This is for the good of the whole community. It is also illegal and will cause flooding, I said. The city engineer has already explained this. The city engineer is being overly cautious, Patricia snapped. We have consulted with our own experts. What experts? I asked. That is board business, she said dismissively. A man named Jeff, who lived 3 houses down from me, raised his hand. I am a little concerned about the flooding issue. My basement already gets damp during heavy rains. There will be no flooding, Patricia said. We will be installing proper drainage. Where? I asked. Did you hire a civil engineer to design a new drainage system? We have a landscape architect who has designed many projects, Patricia said. A landscape architect is not a civil engineer, I said. They are not qualified to design stormwater infrastructure. The meeting devolved into arguments, with about half the homeowners supporting the bike path idea and the other half worried about flooding. Patricia eventually adjourned the meeting, but not before announcing that the board was moving forward with the project. The next morning, I received a certified letter informing me that the HOA was formally requesting an easement across my property for the bike path. They were offering me $500 as fair compensation. I did not even bother responding. Daniel sent them a rejection letter on my behalf. Then came the escalation. The HOA filed a lawsuit against me, claiming that I was preventing necessary community improvements and demanding that the court grant them an easement. They also renewed all their previous fines and added new ones, claiming I now owed over $8,000. Daniel and I countersued for harassment, trespass, and abuse of authority. The legal battle was going to be expensive and time-consuming, but I was not backing down. While the lawsuits were pending, spring turned into early summer. Oregon's rainy season was ending, and the weather was beautiful. My drainage ditch, which had been flowing with runoff throughout April and May, was now just a dry channel lined with rocks and grass. I think this gave Patricia a dangerous idea. On June 15th, I left for a week-long conference in Houston. My company was presenting a new aerospace component design, and my presence was mandatory. I had arranged for my neighbor, an elderly man named George, to keep an eye on my house. I landed back in Portland on June 22nd around 8 p.m. As I drove into my neighborhood, something looked different, but in the dark, I could not quite figure out what it was. I pulled into my driveway, exhausted, and went straight to bed. The next morning, I woke up, made coffee, and walked out my back door to check on my yard. What I saw made me drop my coffee mug, which shattered on the patio. My drainage ditch was gone. In its place was a smooth, dark asphalt bike path, complete with painted white lines and a cheerful yellow sign that read, Sunset Hills Community Trail. I stood there in shock for a full minute before rage took over. I ran back inside, grabbed my phone, and called Daniel. They paved it, I said, my voice shaking. While I was gone, they paved over the entire drainage ditch. What? How is that possible? We have a restraining order. I do not know, but it is done. There is a bike path where my drainage ditch used to be. Do not touch anything. I am calling the police, and then I will be right over. Start documenting everything with photos and videos. I spent the next hour photographing and recording video of the bike path from every angle. The construction was recent. I could still smell the fresh asphalt. They had filled in the entire 15-foot wide, 4-foot deep ditch with gravel and dirt, compacted it, and paved over it with what looked like a professional job. George came over, looking distressed. "Marcus, I am so sorry. They told me they had permission." They showed me official-looking documents. "When did this happen?" "They started on Tuesday. Big crew, lots of machinery. Worked for 3 days straight. They said you had approved it and that the HOA had all the permits." The police arrived, followed shortly by Daniel. Officer Martinez took my statement and examined the bike path. "This is clearly a violation of the court order," he said. "But this is also a civil matter. You will need to pursue this through the courts." "Can you at least find out who authorized this?" I asked. "I can try to talk to the HOA president, but I cannot force her to give a statement about a civil issue." Daniel was already on his phone, photographing everything and making notes. "We are filing an emergency motion first thing Monday morning. This is contempt of court." Patricia and the board could face serious consequences. Over the weekend, I noticed neighbors starting to use the new bike path. Kids rode their bikes on it. People walked their dogs. It was infuriating to watch people enjoy the amenity that had been illegally built on my property. On Sunday afternoon, Patricia herself rode past on a fancy electric bike, wearing expensive cycling gear and a smug expression. When she saw me standing in my yard, she actually waved. I spent the rest of the weekend researching Oregon weather patterns and drainage systems. What I found made my blood run cold. Beaverton typically received most of its rainfall between October and March, but summer thunderstorms were not uncommon. More importantly, the drainage ditch on my property was part of a larger system that managed runoff from a significant portion of the hillside behind the neighborhood. Without that channel, water would have nowhere to go. Monday morning, Daniel and I were in court before Judge Kowalski again. This time, her expression was thunderous as she reviewed the photos and documentation. "Miss Pemberton," she said icily, "would you care to explain why construction occurred on Mr. Oakes's property in direct violation of my restraining order?" Patricia stood, and for the first time she looked nervous. Her attorney, Richard Vance, looked like he wanted to be anywhere else. "Your Honor, there was a miscommunication. The board believed that because we had filed for an easement, we could proceed with the project." "That is not how the law works, and you know it," Judge Kowalski said. "Filing for an easement does not grant you an easement. You violated a court order. I am holding you and the entire HOA board in contempt. Each board member will be fined $5,000, and the HOA itself is fined $50,000. Richard Vance stood quickly. "Your Honor, may I request a brief recess to confer with my clients?" "No. Sit down, Mr. Vance. I am not finished." Judge Kowalski looked at her notes. "Mr. Oakes, what remediation are you seeking?" Daniel stood. "Your Honor, my client wants the bike path removed and his drainage ditch restored to its original condition by a qualified civil engineer. He also seeks compensation for the violation of the restraining order and damages for the ongoing trespass." "Your Honor," Richard Vance said desperately, "the cost of removing the bike path and restoring the drainage system could be over $100,000. The HOA does not have those funds readily available." "Then the HOA should not have violated a court order," Judge Kowalski said sharply. "Here is my ruling. The HOA has 30 days to hire a licensed civil engineer to design a proper restoration plan. Once approved by the court and the city of Beaverton, they have an additional 60 days to complete the work. Failure to comply will result in additional fines of $1,000 per day. Furthermore, I am granting Mr. Oakes's request for damages in the amount of $25,000 for the violation of the restraining order. Do I make myself clear?" "Yes, Your Honor," Richard Vance said weakly. Patricia looked like she was going to be sick. As we left the courthouse, Daniel was grinning. That went even better than I hoped. The contempt finding is huge, and the 30-day deadline to hire an engineer means they cannot drag this out. Do you think they will actually comply? I asked. They do not have a choice. If they do not, the fines will bankrupt the HOA and the board members can be held personally liable. I should have felt victorious, but instead I felt uneasy. The bike path was still there, and the rainy season would be starting again in a few months. Every day that passed without proper drainage was a day closer to potential disaster. The HOA did hire a civil engineer, though it took them almost the full 30 days. The engineer, a woman named Susan Crawford from a respected Portland firm, came to inspect my property in late July. "This is a nightmare," she said, shaking her head as she examined where the drainage ditch used to be. They did not just pave over a ditch. They filled it with unsuitable material, compacted it improperly, and created a dam across a natural drainage corridor. When the rains come, water is going to back up behind this bike path like a levee. "What will happen?" I asked, though I had a pretty good idea. "Best case scenario, you will get flooding in your yard and possibly your basement. Worst case, the water will find a new path, which could undermine foundations, flood multiple properties, or cause erosion and landslides on the hillside above. Can you fix it?" "Yes, but it is going to be expensive and complicated. We need to excavate the entire bike path, remove all the fill material, reconstruct the drainage ditch with proper erosion control, and possibly add additional drainage infrastructure to handle the disruption to the natural flow patterns. I am estimating $150,000 to $200,000. I watched the color drain from Patricia's face as Susan delivered her written estimate to the HOA board at their next meeting. The HOA's annual budget was only about $180,000, mostly funded by monthly dues. They did not have the money for this kind of emergency work. Richard Vance, the HOA attorney, suggested they take out a loan. But when they approached banks, they discovered that lending to HOAs with pending litigation and contempt findings was not easy. The best rate they could get would require a special assessment of nearly $3,000 per household. When Patricia announced this at an emergency HOA meeting in early August, the homeowners revolted. "You are saying we have to pay $3,000 each because you illegally paved over someone's property?" Jeff demanded. "This is for drainage infrastructure that benefits everyone," Patricia said, though her usual confidence was gone. "No, this is to fix your screw-up," said another homeowner, a woman named Maria. "You were told by the city, by the court, and by Mr. Oakes that this was a bad idea. You did it anyway. Why should we pay for your mistakes? As board president, I made decisions in the best interest of the community," Patricia said. "Then you should pay for it personally," Maria shot back. The meeting ended with no resolution. Several homeowners, including Jeff and Maria, announced they were withholding their HOA dues in protest. Others started circulating a petition to remove Patricia and the entire board. Meanwhile, summer was passing, and the bike path remained. I could see the homeowners using it every day, oblivious to the ticking time bomb beneath their feet. I wanted to put up warning signs, but Daniel advised against it, saying it could be construed as harassment. August in Oregon is typically dry, but in late August, we got an unusual thunderstorm. It was not much, maybe an inch of rain over a few hours, but it was enough to show me what was coming. The water that normally would have flowed down through my drainage ditch had nowhere to go. Instead, it pooled against the back of my property, turning my backyard into a muddy swamp. Water seeped into my basement, not much, but enough to soak the carpet in my storage room. I documented everything and sent the photos to Susan, the engineer, who included them in her report to the court as evidence that the drainage problems were already beginning. Judge Kowalski ordered the HOA to begin remediation immediately, regardless of funding issues. Patricia and the board scrambled to get a loan approved, finally securing funding at a brutal interest rate that would require special assessments for the next 3 years. Restoration work was scheduled to begin in mid-September. Susan's team mobilized, and I watched with satisfaction as heavy machinery began tearing up the bike path. The excavation revealed just how badly the HOA's contractors had botched the fill job. They had dumped everything from construction debris to old asphalt chunks into my drainage ditch before paving over it. But then, the weather changed. On September 18th, meteorologists started tracking an unusual weather pattern: a low-pressure system stalling off the Oregon coast, pulling in moisture from the Pacific. They were calling for heavy rain, possibly several inches over multiple days, starting September 20th. Susan called me that evening. "Marcus, we have a problem. We have got the bike path partially excavated, but we have not restored the drainage channel yet. If this storm hits as predicted, you are going to have serious water issues." How serious? I do not know. We have created a partial blockage, and with the natural channel destroyed, the water is going to go somewhere unexpected. I am going to have my crew work overtime tomorrow to at least create a temporary spillway. September 19th was a frantic day. Susan's crew worked from dawn until dark, using excavators to dig a rough channel that approximated the original drainage ditch. It was not pretty, and it was not properly engineered, but it was better than nothing. The rain started just after midnight on September 20th. I lay in bed listening to it drum against my roof, steady and heavy. I got up several times during the night to check my basement and backyard with a flashlight. Water was flowing through the temporary channel, but it was already eroding the loose dirt, and pools were forming in low spots. By morning, Beaverton had received 3 inches of rain, and it was still coming down. I made coffee and stood at my back window, watching the water. The temporary drainage channel was handling the flow barely, but I could see that the hillside above the neighborhood was saturated. Water was sheeting down the slope, channeling into my property and the neighboring lots. Around 10 a.m., my phone rang. It was George, my elderly neighbor. "Marcus, you need to see this. There is water everywhere on the street." I pulled on rain gear and went outside. George was right. The street in front of our houses had water flowing down it like a creek. But that was not the worst part. As I walked toward the end of the block, I could see that the water was flowing toward the HOA Clubhouse, a fancy building that Patricia had pushed to build just 2 years earlier at a cost of $400,000. The clubhouse sat at the lowest point in the neighborhood, positioned perfectly to catch any runoff that did not make it into the drainage system. And with my drainage ditch paved over, blocked, and only partially restored, a lot of water was not making it into the drainage system. I walked closer to the clubhouse, staying on high ground. Water was pooling around the building, at least 6 inches deep in the parking lot. As I watched, a river of muddy water came cascading down from the direction of my property, adding to the flood. My phone buzzed with a text from Daniel. "Are you seeing this rain? How is your property?" I texted back. "Temporary channel is barely holding. Clubhouse is flooding." Several other neighbors had come out to watch. Jeff appeared next to me in a bright yellow rain slicker. "This is bad," he said. "Really bad. My basement has 2 inches of water." "Mine is still dry, but just barely," I said. "Where is all this water coming from?" Jeff asked. I pointed up the hill behind the neighborhood, See those slopes? The drainage ditch on my property was designed to catch all that runoff and channel it to the storm drains, but the HOA paved it over. Oh my God, Jeff said, understanding dawning on his face. This is because of the bike path. Yes. We stood there watching as the water around the clubhouse continued to rise. I pulled out my phone and started recording video. If this turned into a legal issue, I wanted documentation. Around noon, the fire department arrived. Someone had called 911 about the flooding. 2 fire trucks and an emergency response vehicle parked on the hill above the clubhouse. Firefighters in waterproof gear assessed the situation. I watched as they forced open the clubhouse door, and a wave of brown water poured out. The building had flooded, probably with several feet of water inside. Patricia arrived about 20 minutes later, driving her luxury SUV right up to the edge of the floodwater. She jumped out, not even bothering with an umbrella, and ran toward the clubhouse. A firefighter stopped her before she could wade into the water. I was too far away to hear the conversation, but I could see Patricia gesturing wildly, her face contorted with anger or panic. The firefighter shook his head and pointed at the building. Patricia pulled out her phone, probably calling other board members. The rain continued all day and into the night. By the time it finally tapered off on the morning of September 21st, Beaverton had received nearly 7 inches of rain in 36 hours. The flooding around the clubhouse had peaked at about 3 feet deep. Several homes, including Jeff's, had significant basement flooding, and my temporary drainage channel had eroded into a muddy gully that looked like a scar across my backyard. The damage assessment took several days. The HOA clubhouse was a total loss. Water had destroyed the flooring, drywall, furniture, kitchen equipment, and electrical systems. The initial estimate for repairs was $380,000, nearly as much as it had cost to build. But here was the problem. The HOA's insurance company was refusing to pay. I learned this when I received a subpoena to give a deposition for the insurance investigation. The deposition took place in a conference room in downtown Portland. Present were Patricia, Richard Vance, an insurance adjuster named Keith Sanders Daniel, and a court reporter. Keith was a middle-aged man with a weathered face and the look of someone who had seen every scam in the book. He got right to the point. "Mr. Oakes, please describe the drainage ditch that was on your property and its function." I explained the entire history of the original drainage system, how it was documented on my survey, its essential role in managing stormwater, and how I had tried to protect it. "And the HOA paved over this drainage system against your wishes and against a court order?" Keith asked. "Yes." "Were HOA board members, specifically Miss Pemberton, aware that paving the drainage ditch could cause flooding?" "Yes. They were told by me, by my attorney, by a city engineer, and by Judge Kowalski." Keith made notes. "And the construction that paved the drainage ditch, when did that occur?" "June 19th through June 21st, while I was out of town." "Thank you, Mr. Oakes." Keith turned to Patricia. "Miss Pemberton, did you authorize the construction that took place on Mr. Oakes's property in mid-June?" Patricia's face was pale. Richard Vance whispered something to her. "I plead the Fifth Amendment," Patricia said quietly. Keith raised his eyebrows. "You are invoking your Fifth Amendment right against self-incrimination in a civil deposition regarding an insurance claim." "Yes," Patricia said. "That is very interesting," Keith said, making more notes. "Let me be clear about the insurance company's position. Your HOA's policy does not cover flooding caused by the willful and knowing destruction of drainage infrastructure. Based on Mr. Oakes's testimony and the court records I have reviewed, it appears that the flooding damage to your clubhouse was the direct result of the HOA's deliberate decision to pave over a drainage ditch, despite being warned of the consequences, and despite a court order forbidding such action. Therefore, we are denying your claim. Richard Vance tried to argue, but it was hopeless. The paper trail was clear, and Patricia's decision to plead the Fifth had essentially confirmed that she knew what she was doing was wrong. After the deposition, Daniel and I grabbed lunch at a nearby sandwich shop. "This is turning into a bigger disaster for them every day," Daniel said. "No insurance payout means the HOA is on the hook for all the clubhouse damage. Plus, they still have to finish restoring your drainage ditch. Plus, they owe you $25,000 in damages. And now homeowners whose basements flooded are talking about suing the HOA too." "How much total are we talking about?" I asked. "Conservatively, at least $600,000. The HOA's annual budget is less than $200,000, and they already took out a loan for the drainage restoration. They are essentially bankrupt." "What happens to a bankrupt HOA? Legally, it depends. They might have to do a massive special assessment, levy huge fees on all homeowners, sell off assets, or potentially dissolve. And individual board members could potentially be held personally liable for damages resulting from their gross negligence." Over the next few weeks, the situation deteriorated further. 6 homeowners filed lawsuits against the HOA for flood damage to their basements. The total damages claimed exceeded $150,000. Susan completed the restoration of my drainage ditch, and the HOA received a bill for $187,000, significantly over the original estimate due to the additional erosion damage caused by the September storm. At an emergency HOA meeting in early October, Patricia faced a room full of angry homeowners. Maria, the homeowner who had been critical of Patricia before, had organized a recall effort and collected signatures from over 70% of the neighborhood. "You have destroyed this HOA," Maria said, standing up during the public comment period. "Your illegal actions, your contempt of court, your refusal to listen to experts, all of it has led to financial ruin. The clubhouse is destroyed. We are facing lawsuits, and now you want to assess each homeowner another $4,000 to cover the costs. It is unacceptable." "I did what I thought was best for the community," Patricia said, but her voice lacked conviction. "You did what you wanted regardless of the law," Maria shot back. "And now we are all paying for your arrogance." The board was formally recalled that night. Maria was elected as the new president, along with an entirely new board of homeowners who pledged transparency and fiscal responsibility. But the damage was done. The HOA was drowning in debt and legal judgments. The new board met with an attorney who specialized in HOA law, and their advice was grim. The HOA would need to levy special assessments totaling nearly $6,000 per household to cover all obligations, or they would need to file for bankruptcy protection. In November, more consequences arrived. I was at home one evening when I saw 2 police cars pull up to Patricia's house, 3 doors down from mine. Officers approached her front door, and after a brief conversation, I watched as Patricia was led out in handcuffs. I later learned from Daniel what had happened. The Washington County District Attorney's Office had been reviewing the case after the insurance company filed a fraud complaint. While the civil matters had been playing out in court, prosecutors had been quietly building a criminal case. Patricia was charged with 3 felony counts: criminal trespass in the first degree, criminal mischief in the first degree for the property damage exceeding $1,000, and theft in the first degree for misappropriating HOA funds to pay for the illegal construction project. 3 other board members who had voted to approve the bike path construction were charged with lesser offenses. The criminal trial took place the following March. I was called as a witness and testified about the property destruction and the violation of the court order. Susan, the civil engineer, testified about the extent of the damage and the costs to repair it. The city engineer, Tom Peterson, testified that he had explicitly warned the HOA that paving the drainage ditch would cause flooding. The most damning evidence came from the HOA's own records. Prosecutors had subpoenaed all board meeting minutes and emails. They showed that Patricia had received the court's restraining order, had been explicitly warned about the flooding risks, and had proceeded anyway, even going so far as to schedule the construction while I was out of town to avoid confrontation. In one email to another board member, Patricia had written, "Once it is done, it will be too expensive for him to make us tear it up. We just need to present him with a fait accompli." That email, displayed on a large screen in the courtroom, essentially proved criminal intent. The jury deliberated for less than 3 hours. Patricia was found guilty on all 3 felony counts. The other board members took plea deals. At her sentencing hearing in April, the judge was not sympathetic. Patricia's attorney argued that she was a community volunteer who had made a mistake in judgment. The prosecutor countered that she was a person who had willfully violated the law, ignored court orders, and caused hundreds of thousands of dollars in damage to pursue a vanity project. Judge Kowalski, who had overseen the civil case, testified at the sentencing hearing about Patricia's contempt of court and her blatant disregard for judicial authority. Patricia was sentenced to 18 months in prison, followed by 3 years of probation. She was also ordered to pay restitution of $187,000 to the HOA for the drainage restoration costs and $25,000 to me for damages. Given that Patricia and her husband had already spent over $100,000 in legal fees and were facing personal bankruptcy, the restitution order was largely symbolic. The other board members received sentences ranging from probation to 6 months in county jail. As for the HOA itself, the new board under Maria's leadership made the difficult decision to dissolve the organization. They had consulted with homeowners and legal experts and determined that the debt burden was simply too great. The clubhouse was sold to a developer at a significant loss. Common areas were deeded over to the city of Beaverton. Individual homeowners became responsible for their own property maintenance. Some neighbors grumbled about losing the HOA's services, but most were relieved to be free from the assessments and legal drama. My drainage ditch was restored to perfect working order. Susan had done excellent work, installing proper erosion control, native vegetation, and even some aesthetic touches like decorative boulders. It looked better than it had originally, and more importantly, it worked flawlessly. When the next round of heavy rains came in November, the water flowed exactly as it was supposed to, and my basement stayed completely dry. Jeff, whose basement had flooded during the September storm, came by one afternoon to look at the completed restoration. "You know, I owe you an apology," he said. "When Patricia first proposed the bike path, I thought it sounded nice. I did not understand the engineering behind the drainage system. I am sorry I did not support you earlier." "No hard feelings," I said. "A lot of people did not understand." Patricia was very convincing. "Still, you were right, and you stuck to your guns even when everyone was against you. That takes courage." We stood there watching the water flow through the ditch, carrying leaves and debris safely away from our properties. "What are you going to do with the money from the court judgment?" Jeff asked. I had received my $25,000 in damages, paid directly by the HOA's insurance before they dissolved. Patricia's personal restitution would probably never materialize, but at least I had gotten something. "I am using it to finish restoring my Mustang," I said, "and maybe take a vacation somewhere warm. I have had enough of Oregon rain for a while." Jeff laughed. "I do not blame you." The following summer, I was working in my garage on the Mustang when Maria stopped by. As the former HOA president during its dissolution, she had stayed involved in neighborhood issues even after the organization was gone. "I wanted to give you this," she said, handing me a folder. Inside were letters from various homeowners thanking me for standing up to Patricia and the old board. Some were apologetic, acknowledging that they had not understood the situation. Others were simply grateful that the legal nightmare was over. "That is very kind," I said, genuinely touched. "You saved this neighborhood, Marcus." If that drainage ditch had stayed paved over, we would have had catastrophic flooding during this spring's storms. Multiple homes could have been destroyed. You fought the fight that needed to be fought, even when it was difficult. "I was just protecting my property," I said. "You were doing more than that, whether you realized it or not. You were standing up to someone who thought rules did not apply to her, who thought she could bully people into submission. A lot of folks were afraid to challenge Patricia. You were not." After Maria left, I sat in my garage, reading through the letters. One was from a young couple who had just bought a house in the neighborhood and had been terrified when they learned about the flooding and legal issues. Another was from an elderly widow who had been intimidated by Patricia for years over trivial violations. I realized that the drainage ditch had become symbolic of something larger, the importance of standing up for what was right, even when it was inconvenient, even when you were standing alone. The Mustang restoration was complete by August. I took it to a classic car show in Salem and won second place in the 1960s class. Driving home with the trophy on the passenger seat, I took a detour through my neighborhood, past the empty lot where the clubhouse had stood, past Patricia's old house which now had a "for sale" sign in the yard, and finally back to my own driveway. George was outside watering his garden. He waved as I pulled in. "Nice trophy," he called out. "Thanks. Want to see the engine?" We spent the next hour with the hood up, George admiring the rebuilt V8 while I explained the restoration process. We did not talk about the HOA or the bike path or any of it. That chapter was closed. But that evening, as I sat on my back patio with a beer, watching the sunset paint the sky orange and purple, I looked out at my drainage ditch. The native grasses were growing in thick and healthy. A family of ducks had taken up residence, using it as a corridor between the hillside and the wetlands a few blocks away. Water trickled quietly along the bottom, carrying away the day's irrigation runoff. It was just a drainage ditch, an unglamorous piece of infrastructure that most people would not look at twice. But it was my drainage ditch, on my property, serving its essential function, and I had fought like hell to protect it. I raised my beer in a silent toast to drainage ditches, to property rights, to standing your ground, and to sometimes winning against the odds. The next morning I got a call from Daniel. "Marcus, I wanted to give you a heads up. The Oregon State Bar Association is doing a presentation on HOA law and abuse of authority. They have asked to use your case as an example. Are you comfortable with that?" "Will I have to do anything?" I asked. "Just potentially answer some questions if they have any. But mostly they want to use the court records and outcome as a teaching tool for attorneys and HOA board members." "Sure, that is fine. If it helps prevent this from happening to someone else, I am all for it." "Great." Oh, and one more thing, Patricia's attorney filed an appeal on her criminal conviction. "Just wanted you to know, though I do not think it is going anywhere. The evidence was pretty overwhelming. Let me know if anything comes of it, I said. The appeal was denied 3 months later. Patricia began serving her prison sentence at Coffee Creek Correctional Facility in Wilsonville. According to news reports I saw, she was also facing several civil lawsuits from homeowners seeking to recover their flood damages personally from her, since the HOA had dissolved. Meanwhile, life in the neighborhood returned to a new normal. Without an HOA, people were free to paint their houses whatever colors they wanted, park their RVs in their driveways, and let their grass grow a bit longer. Some people loved the freedom. Others missed the uniformity and rules. But everyone agreed that the drama was over, and that was a relief. I ran into Tom Peterson, the city engineer, at a coffee shop in November. He recognized me and came over to my table. "Mr. Oakes, I wanted to thank you," he said. "For what?" "For fighting that battle. We see situations like yours more often than you would think. HOAs that think they know better than actual engineers, that ignore physics and hydrology because they want something to look pretty. Usually, homeowners give up because the legal fight is too expensive and exhausting. You did not give up, and you were proven right in the most dramatic way possible." "I do not know if I would call it dramatic," I said, though of course it had been exactly that. "A destroyed clubhouse and a felony conviction. That is pretty dramatic," Tom said with a smile. "But seriously, the city is now using your case in our training for new engineers. It is a perfect example of why we have drainage codes and why they matter." "Happy to be a cautionary tale," I said. "A success story," Tom corrected. "The cautionary tale is what happened to the HOA." As the 1-year anniversary of the September flood approached, a local news station reached out to me about doing a story. They wanted to cover the aftermath, the criminal convictions, the dissolved HOA, and the restored drainage ditch. I was hesitant at first, but Daniel encouraged me to do it. "This is important for people to hear about. HOA abuse is a real problem, and most people do not know they have rights. Your story could help someone." The news segment aired in late September. They interviewed me in my backyard, with the drainage ditch prominently featured. They showed before and after photos of the illegal bike path. They interviewed Susan about the engineering failures. They even got a brief statement from Maria about the HOA's dissolution. The segment ended with the reporter standing in front of the empty clubhouse lot. This vacant lot is all that remains of the Sunset Hills HOA clubhouse, a $400,000 facility destroyed by flooding that engineers say was entirely preventable. Former HOA President Patricia Pemberton is currently serving an 18-month prison sentence for her role in the illegal construction project that caused the flood. For homeowners dealing with difficult HOAs, Marcus Oakes' story is a reminder that property rights matter, and that standing up to abuse of authority, while difficult, is sometimes necessary. The segment went viral, at least by local news standards. It was shared thousands of times on social media, and I received emails and calls from people all over Oregon and beyond who were dealing with their own HOA nightmares. I could not help them all, but I referred them to Daniel and other attorneys who specialized in property rights. One woman from Bend sent me a particularly touching email. She was fighting her HOA over a vegetable garden they claimed violated aesthetic standards. My case had given her the courage to fight back. 6 months later, she sent me a photo of her thriving garden and a court order in her favor. "Thank you for showing me that HOAs are not all powerful," she wrote. "Sometimes David beats Goliath." I printed that email and kept it in my office. By the time winter arrived again, bringing Oregon's characteristic gray skies and steady rain, my drainage ditch was performing perfectly. I had installed a rain gauge in my backyard, and I would sometimes check the water flow during heavy storms, watching thousands of gallons safely channeled away from my property and my neighbors' homes. One particularly heavy rainstorm in December reminded me of the flood from the previous year. I stood at my back window watching the water rush through the ditch, grateful for Susan's excellent engineering work. My basement was dry. My yard was not flooding. Everything was working exactly as it should. I thought about Patricia, sitting in prison, probably not even aware that it was raining. I wondered if she ever reflected on the choices that had led her there, the arrogance, the assumption that she knew better than engineers and judges, the willingness to violate the law to get what she wanted. Probably not. People like Patricia rarely accepted responsibility for their actions. But that was not my concern anymore. My fight was over. My property was restored. Justice, in its imperfect way, had been served. I made myself a cup of coffee and went back to my garage, where the Mustang sat gleaming under the fluorescent lights. I had a few minor adjustments I wanted to make to the carburetor. Outside, rain drummed on the roof, and water flowed safely through my drainage ditch, doing exactly what it was designed to do. It was not dramatic. It was not exciting. It was just a drainage ditch working properly. And that, I realized, was the whole point. Sometimes the most important battles are fought over the most ordinary things. Sometimes standing up for what is right means defending something as unglamorous as a ditch full of rocks and grass. Sometimes doing the right thing costs you time, money, and stress, but it is still worth doing. I picked up my wrench and got back to work on the Mustang, content in the knowledge that my property was secure. My rights had been defended, and my drainage ditch would continue doing its quiet, essential work for years to come. The neighborhood had learned an expensive lesson about the dangers of unchecked HOA authority, about the importance of listening to experts, and about the consequences of putting aesthetics over engineering. It was a lesson that had cost hundreds of thousands of dollars, destroyed a building, resulted in criminal convictions, and dissolved an organization. But in the end, the water still flowed downhill, following the path of least resistance, obeying the laws of physics regardless of what any HOA board might have wanted. And my drainage ditch, restored and functional, stood as a permanent reminder that nature does not care about your rules, your bylaws, or your bike path. Physics always wins. I finished adjusting the carburetor, cleaned my tools, and closed up the garage for the night. Tomorrow was supposed to be sunny, a rare break in the Oregon winter weather. Maybe I would take the Mustang for a drive, cruise along the Columbia River Gorge, enjoy the freedom of the open road. But tonight, I was content to sit in my warm house, listening to the rain, knowing that every drop falling on my property was being safely channeled away by a perfectly functional drainage ditch. It was a simple thing, really. But sometimes the simple things matter most.